Hello, I'm Roger Citron, and today this Toro Law Review podcast is brought to us courtesy of the Toro Law Review and also courtesy of the Toro College Jacob D. Fuchsberg Law Center. Our guest today is the Honorable Alan Scheinkman, and before we talk about the bar exam, Judge, can you please tell us a bit about your background and how that ties into our subject of the bar exam?
Well, I've been both a law professor, practicing lawyer, and sitting judge. Most going backwards in time for 3 years, ending in January of this year. I was the presiding judge of the Appellate Division, Second Department. Prior to that, I was a Supreme Court Justice in the Ninth Judicial District, which consists of 5 lower Hudson Valley counties, including Westchester, and was presided in the commercial division of that district, as well as matrimonial, contract, occasional criminal cases. And I was the administrative judge for 8.5 years. I was elected to the Supreme Court in 2006. Prior to that time, I had been in private practice and governmental service. My governmental service included 3 years as the Westchester County Attorney, which has the job of being the legal advisor to the county executive, board of legislators, and all agencies of the county government. For about 8 years, I was a full-time member of the faculty at St. John's Law School. I had the opportunity to work with you, to my great pleasure, as well as your colleague, Eileen Kaufman, when we were all reporters to the State Supreme Court Judges Committee on Civil Pattern Jury Instructions. And when I became a judge, I was privileged to serve as a member of that group for quite some time. I've done a whole bunch of other things, but probably is what is most germane to our discussion today is I was asked to chair the State Bar's task force on the bar exam. And I've done that for about 3 years now.
And can you just tell us a little bit more about the task force itself, who's on it, and what work you've done?
So the task force was formed in 2019 or so by then President of the State Bar, Michael Miller, to take a look at what had happened in New York since the adoption of the uniform bar exam. And the task force was composed of a number of judges, myself and a couple of others, a number of academics. Professor Eileen Kaufman from Toro was on it. Professor Peggy Turano, Margaret Turano from St. John's was on it. Professor Pat Connors from Albany Law School was on it. And a wide swath of lawyers from large firms, medium-sized firms, public service, and small firms throughout the state of New York.
Thank you. And I guess we can now turn to our subject fully in front of us, which is the bar exam itself. And I've been teaching at Toro since 2004, and there was a time when New York offered its own bar exam. And I guess that changed in around 2016. What happened?
Well, actually, I can take you back a little further, which is when I took the bar, which was many years ago, long before you started teaching at Toro. It was an entirely New York experience. The Board of Law Examiners had the responsibility for writing and grading an entirely New York exam. And that's the way it was in New York for probably 100 years. In the early 1980s, New York adopted the multi-state bar. So instead of having a 2-day all New York bar, there was a 1 day that became known as the New York Day. And then there was 1 day that was the multi-state exam, which was a multiple choice test that is compiled by the National Conference of Bar Examiners. At some point, the New York Day got whittled down a little bit when they started to offer a performance test for part of the New York Day. And then in 2016, New York went with the uniform bar exam, and New York law was relegated to a test, if you want to call it that, called the New York law exam, which is a series, open book series of multiple choice tests.
Yes. So I recall I graduated law school in 1992. So my classmates were in that, I guess, second era that you described, which is the MBE on one day, the New York law exam on the second day. What's your understanding as to why New York in 2016, I guess, fully adopted, I'll call it the uniform bar exam as a way of
shortening. The argument for it is that it was supposed to increase portability of lawyers, so that when I went to law school, you took the 2-day New York test, and if you wanted to be admitted anyplace else, you had to take such test as the jurisdiction required you to take. I knew colleagues who I went to school with who decided to take a test in Connecticut, decided to take a test in New Jersey. You had to take another bar exam, which could be 1 day, it could be 2 days, depending upon what that state's requirement was. The adoption of the multi-state made it somewhat easier for people to be admitted in other states, because you could take your MBE score and use that as part of your score in the other jurisdiction, so that you didn't have to take the whole thing all over again from scratch. The UBE took that one step further by saying, okay, we're going to have you take one test, and you can use this one result to get admitted in whatever jurisdictions are UBE jurisdictions. New York, which admits about 15,000 lawyers let me backtrack, has about 15,000 test takers a year, was what the largest state, and still I think is the largest state to fully adopt the UBE. When New York went with the UBE, there were about 17 states, mostly small ones, that had adopted it. After New York adopted it, another 17 or so joined. So now there are about 35, 36 states that are full UBE states. Some states like New York have some local requirements, many don't.
Yes, and I guess while we're setting the table here, you made reference to what is known as the New York law exam. And I will say this somewhat jocularly, the so-called New York law exam. What is that, and what is it supposed to do, and what's your impression or the task force view of it?
So that's one of the reasons why we were commissioned to look at this whole thing, because of the New York law exam. Even the board of what there is a great deal of confusion about what the New York law exam was supposed to be and what it is. When the UBE was adopted, there was a great deal of opposition to it within the bar and elsewhere. And Judge Lippman, the chief judge at the time, had said to those who complained that New York law wasn't going to be tested anymore, during the adoption phase, he said, don't worry about it. We're still going to have a rigorous test on New York law. So we had some people saying it was supposed to be a rigorous test. The Board of Law Examiners said, no. It's just supposed to encourage, this and the associated course that you have to take are supposed to just sensitize people to the fact that New York law may be different than whatever it is they test on the UBE. And it's not really a test. It's supposed to be, for lack of a better term, a sensitivity training exercise in which your consciousness is raised to the fact that there may be differences. The Board of Law, it's I think 100 questions, 60 is a passing score, which I find unusual. But you'd be surprised to know that there are people who fail it. It's open book, and one of the distressing, even the Board of Law Examiners acknowledges that the initial versions of it, and bear in mind there have only been about 4 or 5, were too easy. I think one question was literally like, can you name like the highest court in New York is the court of, and then it was like apples, oranges, pears, appeals. And even with that, we were hearing, and during the task force, we documented unfortunate instances of cheating, notwithstanding the fact that applicants are required to sign an affirmation saying that they don't cheat. But we know that they do, because they sit around and take the test together, because unlike the remote exam that we just went through with the pandemic, there was no remote proctoring. And so to try to, all right, we know, the Board of Law Examiners said, well, we know how to fix this. We're going to mix up the order of the questions so that when you take the exam, if you and I were taking it, your question 1 might be my question 40. My question 60 might be your question 3. But law students are not silly people, and they're bright. And hey, Mary, what did you get for question 70? Hey, what did you get for this question? And it's really unfortunate that, first of all, the people feel the need to cheat on an easy exam, and more importantly, more significantly, that the first act towards getting admitted is filing an affidavit that is not policed, is not regulated, and in many instances not true.
I guess.
And I don't think I've said anything that any member of a law school faculty won't acknowledge is true.
When I was the academic dean, a job I had when the UBE was implemented, I certainly had some exposure to the New York law exam, and it was an important thing to say to students. At most, this is the tail. The real exam comes in July or February with the uniform bar exam itself. So that was certainly something that we were familiar with. And can we, I guess, drill down a little bit more on the current iteration of the UBE, the types of questions that are asked? I know that you wrote a piece for Bloomberg about the exam, and you had this marvelous phrase, the law of nowhere, and perhaps we could talk about that a little bit. And then there's a third piece, and we can do these one at a time, of course, but there's the computer piece, which seems, in our current condition with the pandemic, or our current state with the pandemic, that offering to use the word digital, right, an online exam seems to be certainly part of the present, or somewhat part of the present, as well as the foreseeable future. So again, let's come back to the.
Right, that's an awful lot to cover. I disclaim ownership of the phrase "law of nowhere," but it's a phrase that has a lot of trenchancy. So the current iteration of the UBE consists of a couple of components. It consists of the multi-state bar exam, which is the multiple choice portion of the exam. It consists of the multi-state essay exam, and it has some performance tests associated with it. That's where they give you a library of materials, and they ask you to then compose a response to the problem using the materials that you've been given, the idea being that this is supposed to show one's analytical skills. And those individual pieces are separately graded, and they are smushed together to achieve a score. Just so you understand, and this is and I know I may be jumping ahead a little bit, but just to put things into context, the score is a relative one. So in theory, the object of the exercise is to determine whether someone has at least meets the minimum qualifications to practice law someplace. I say someplace because it could be anywhere in the country if it's the UBE, or in New York. But you're judged, the scoring of the UBE, which is very opaque. They don't tell you how they do it, basically. But what we do know is that you're graded relative to the other people you take the test with. So if you take the test in New York, you're graded against the people who took the test in New York. That same day, they may be giving that test in Montana. If you're taking the test in Montana, you're graded relative to the other people who are taking the test in Montana, so that you could get a higher score in Montana by being the best of the Montanians, and you could get a lower score in New York by being one of the worst of the New Yorkers, even though your scores are exactly the same. Your answers to the question are exactly the same. And that's even before you get to the issue of the fact that each state sets its own pass-fail score. So that's kind of the UBE environment. To get to the computers, so it's always been the case, at least as long as I can remember, that since the advent of the computer, people were permitted to use their computers to formulate their answer, meaning that at least for their essays, so that in the old days when I took the test, they taught you how to make notes on a scratch pad and don't start writing your answer until you would really had a good outline, because otherwise there was no way to cut and paste. You have to rewrite the whole thing, and they weren't necessarily big on giving you more answer books, and you'd have interdelineations and say read this first. And so the advent of the computer really made essay writing much easier, particularly as we got to generations of law students who knew how to type. Now it's called keyboard, but in those days it was called typing. And if you could type and you could cut and paste, this was great. And it also eliminated any issues with the grader reading your handwriting. With the advent of the pandemic, the courts had to make a difficult choice, which was have an exam or not have an exam. I know that there were probably many of your students who were pushing for what was called diploma privilege. Hey, we went to law school. Please let us graduate and be admitted just simply because we went to law school. The problem with that from a judicial point of view, and I think most of the states that considered the issue had problems with it, is that the states don't control law school admission policies. They don't control law school grading policies, and they don't control law school curricula for the most part. So not having any say in who got admitted and whether the people who got admitted were rightly admitted, having the aptitude and the ability to be lawyers, not having any real control over the substantive courses that they take or don't take, and then not having any control over grading. And there are some law schools that have pass fails, by the way, and some, and I mean totally, and there are some that have only some courses that are pass fail. There had to be a way of assuring that the people who are taking the exam have met some minimum standard and can demonstrate that in some appropriate way. So most states did not opt for the diploma privilege. Most opted for a test. In a pandemic, when you couldn't get 1,000 people or 2,000 people in the Javits Center next to each other, working, the best alternative that anybody could come up with was a remotely proctored test, which used facial recognition technology to verify that the person who was taking the test was the person who it was purporting to be, and it wasn't a ringer, and that the person who was taking the test didn't have any improper materials around and wasn't, having a professor or a family member or somebody, sit next to them, helping them answer the questions. So now there were some issues with that technology. There are some complaints that we found to have merit as to whether or not that recognition technology works in the first place. May lock up people's computers, and there may be software clashes. There were some concerns as well that it doesn't, the visual technology was unkind and inappropriate towards racial minorities. Darker skinned people did not show up as well, and people thought they weren't there. People couldn't detect them as well. So there were elements of racial discrimination that was built into this. And there were also issues with comprehension. Let me explain what I mean by that. There are some studies now that are coming out that suggest that people don't comprehend as well, as efficiently, reading on a computer screen as opposed to paper. And even when using an electronic device, there are some electronic devices that may be more conducive to human comprehension than others. So, for example, the Kindle ebook has been widely cited as something that promotes comprehension because, I guess, of the way it's backlit and the way that the light appears on it. Whereas reading on a computer screen that's in front of you is more difficult. In addition, there are certain forms of test formats that create problems, particularly the performance test. A lot of people, including our task force, think there's a great deal of value to performance tests. The problem with a performance test, however, is you get a library of materials that are about 25 pages delivered in a PDF format. And now you've got to compose an answer. It's not as easy to go back and forth in a PDF document as it is on paper. So if you read the problem, if you read the library and then you start writing your answer, and then you want to say, wait a minute, what was that case I read? What was that? What was the exact text of that I read? You want to go back, and if it's on page 14, you got to go find it. It's not like you can put a physical bookmark in a book or dog ear or put a pencil note on a hard copy and get back to it as readily. And we are very concerned that the use of computer delivered tests where you don't have a hard copy in front of you makes it more of a test of one's computer skills than of one's analytical or legal ability. And the reason why this is relevant, and I know that this may sound like more stream of consciousness, but I actually have an end place that I'm trying to get to, Roger, which is the NCBE envisions for its next iteration of its bar exam that the test would be delivered solely by computer, that test takers would not have a hard copy. Their vision is that you would have your computer, the exam would appear on your computer, and you would submit your answer. You wouldn't have a hard copy. It would be proctored still, but it would be delivered on a hard copy, and not only digital. And we were very surprised that they recommended this, because the first and only time that an exam had been done this way was in October with the October 2020 remote exam. The NCBE's recommendations for its new model of exam came out in January. And it does not appear, they certainly didn't say that they did, that they made any effort to evaluate the results of the use of the digital exam, digitally delivered, before deciding to make this ongoing a permanent feature. And we really don't see the necessity for it. We think at the very least, test takers should have the ability to have access to a hard copy.
Yes. So, and I want to try and unravel the different pieces that we've talked about, because in sort of understanding, the task force position and where that could lead New York, or where the task force thinks New York should go. And so, let's say that, we're talking about an exam entirely offered on computer. The principal concern there, if I understood you correctly, was especially related to one part of the exam the performance test, right? This is the write a letter to the client. Here's the file. You have 90 minutes to tell the client what should the case settle for, or something like that. Do you also have those? Then there are the essays, which are short. There's about a page long, and then I wonder whether you have the same types of concerns with respect to that part of the exam. And then, of course, there's the multiple choice questions. So yes.
The concerns with the use of a computer delivered exam are not as strong with the other areas. So, for example, there may not be an inherent problem with answering a multiple choice question on a computer, although again, we have concerns about comprehension, and there are people who do have reading challenges and disabilities, and that creates an issue. So again, while it's most pronounced with the performance test, those concerns go beyond that, and at the very least, we think this issue needs to be studied more before it's adopted. On the essay exams, we would actually prefer longer essay exams. One of the things that you hear from almost everybody in our profession, judges, lawyers, clients, is that lawyers coming out of law school don't write terribly well. Maybe it's a generational thing, and that this generation is used to tweets and trying to express their thoughts in 26 words, or using abbreviations that I don't understand. Although I do know what LOL means, I think, and WTF, but that one's a little off color. One of the things that we think lawyers should be able to do is to be able to effectively communicate what's in his or her brain. And we've been concerned for a long time about the NCBE. The NCBE likes multiple choice questions because they're easy to grade. And to their mind, there's an objective answer. They don't like essays because they think grading them is subjective. I don't necessarily subscribe to that. But because they think it's essay grading is too subjective, they actually curve, they would use the word score, the essay to the multiple choice, meaning that they would find it unacceptable for somebody to get a 90 on the multiple choice and a 50 on the essay. So they would assume that the essay grade is wrong and therefore scale it so it more matches, and vice versa. Not only do we think this is intellectually dishonest, it also tends to discriminate against women. We don't know why, but there's a long history of study that suggests that women do better on tests in which they can express themselves, while men tend to do better on tests that are multiple choice. So when you and you deliberately score the quote unquote objective part of the test and give that more weight than the essay portion, you're actually discriminating against women. The NCBE's response to that is, yes, we know that happens, but the UBE is not any worse at it than any of the prior exams, which I found to be a unsatisfying response. That's like, somebody in the South saying in the 1950s, yes, we know we discriminate, but we don't discriminate any worse than we did 10 years ago. That's just unacceptable.
And I want to pick up one thread, and then I want to sort of talk about where New York is and where it may be headed. There's one more piece of this, and this, in my experience, and this really goes back to 2016, because at the law school, there were a number of courses in which we had to talk to professors and say, you have to teach uniform principles or nationwide principles in your course so that we don't want you to not teach New York, but the course coverage is incomplete. And off the top of my head, what I recall is, I think family law in New York in some ways is
family law, trust and estates, New York civil procedure,
corporations, I think, or business organizations. I thought was another area where there were deviations or differences. And I guess I want to make sure I have a sense of, or I want to ask you to get a sense of how much that figures, into
an awful lot.
Go ahead. Yes, thank you.
An awful lot. First, Professor Deborah Merritt, who's a scholar at Ohio State, has published some studies on bar examinations. And one of the things that emerges out of her work is that newly admitted lawyers, more than half of them, use only state and local law in their initial practices. And even those in the other 50% use primarily state and local law. Obviously, it would be very difficult for the NCBE to have a uniform exam that tested the laws of 37 jurisdictions. So they test federal law, because that's unique to everybody, at least in the sense of civil procedure and evidence. And they test principles that they consider generally accepted. My favorite example of that is the model probate code, which has been adopted in its model form by exactly 0 jurisdictions. And where it has been adopted, there are great variations in what they have adopted, and some of which are inconsistent. Even though in New York, our Board of Law Examiners said this wouldn't happen, in many law schools are incentivized to teach to the test. Why? Well, a couple of reasons. Well, most law students are practically oriented, and they only want to know what's going to be on the test that they have to take to get into the profession. Then we get to law school economics, which is law schools are ranked. They want to, particularly in an era where we had probably more seats than we had applicants for them. Law schools want students. Law school students look to get value for their money. So therefore, law school ranking becomes important. The ABA, which accredits law schools, has increasingly looked at the law school's rank on the bar as an important feature in their ranking and in their accreditation process. So law schools want their law students to pass the bar. They don't want to have the satisfied students. You mean I went here 3 years and I spent all this money and you didn't teach me to pass the bar? So they want to teach the test, and that drives curriculum. Now, when you tell a professor, you suggest to a professor, listen, you got to teach this model penal code and not the New York EPTL, or you can teach them side by side, and you don't increase the number of course hours. As you know as a professor, as I know when I taught, you add material, that means you have to take something else out. And so what went out? The state-specific law, which we think, and Professor Merritt's study confirms, is actually what people need. And the benefit, I guess, is to try to get to the bottom line. So why do we have this bar exam? I'll start where I began, which is it's supposed to assure the public that lawyers are at least minimally competent to practice. I would finish that sentence by saying minimally competent to practice in the jurisdiction in which they seek admission. The NCB would not add that. Their theory is if you're competent to practice in one place, you're competent to practice anywhere because you can always look up the law. Here's the fallacy with that, which goes to law office economics. You're a newly admitted lawyer. You don't know anything about New York law, but you're admitted because you practiced a national test. Somebody comes to you and says, I'd like you to write a will for me. You got to find the law, right? You got to look it up. Who's paying you for that?
I take it the question's rhetorical, but I'll bite. The client.
Or not.
Or not.
Because when you send the client the bill that says, I spent 20 hours to try to figure out how to write your will, clients gonna say, what, I have to pay for your legal education? Even in the big firms, the big Wall Street firms, which traditionally had big training programs for new lawyers, the law firm economics are such, and client resistance to billing is such, that doesn't happen. Even in prosecutors' offices and legal aid organizations, the same issue. They only have so many spots. They can't afford to have somebody taking up a line in their budget who's not producing, because they got to look everything up. We believe strongly that if you want to practice in New York, you have to know something about New York law, and the best way to judge that is by a real New York test. Ironically, when we went through the pandemic in New York, and I talked to a lot of law students, probably some of yours, who said, why can't we have diploma privilege? One of their best arguments is, well, you're making us take this test that has no relevance to what we actually intend to do. Because we want to stay here and practice in New York, and you're not asking us anything about New York law. And yes, that's a fair point, but we had no other test that we could offer them. We would have a different test. Now, the argument, as I said at the beginning, in favor of the UBE is it makes it easier for a lawyer to go from state to state to state. Our view is what's important in a test is not one's ability to take it to other places, but what's important is to protect the public against incompetent lawyers. If you're not doing that, there's no point in having a test.
The last question, and it may be a compound question, which I should be wary of, but the last subject I want to touch on is, so, where is New York now, and where may it be headed? And I guess the compound part of it, or additional compound part of it, would be, where should it go in the view of the task force?
So originally, we produced a number of reports. In our original report, we said, look, we should maybe have a compromise here and offer test takers a choice. So offer the MBE, that we all agree that that's part of something that should be offered. And then say to a student, let's say a student from Touro who only wanted to stay in New York, say, okay, you want to be admitted in New York, take the New York test. Let's say the Touro student said, I really want to just go to Ohio. I don't take the New York test. Instead, take the second day of the UBE. But you won't get admitted in New York. And if you want to go to Ohio and New York, you have to have 3 days. But at least this way, we have no interest in trying to make people who don't want to stay here learn New York law. On the other hand, we have every interest in making people who want to stay here and come here to practice learn New York law. So that seemed like a fair compromise. The problem now is that the NCBE, maybe in response to that, said, oh no, in our future test, we are not only are we going to take out testing on matters of state law, so your answer to family law is they're not going to test it anymore. Your answer to trust and estates is they're not going to test it anymore. So not only are they going in the exact wrong direction on the substance, not only are they going the wrong way on the mechanism of delivering the test, but they're also now saying, you're still going to have 2 days of testing, but we're not going to have the components that we now have. It's not going to be an MBE, the MME, or the performance test. It's going to be 2 days of an overall, as we would say, gestalt. So day one might be some multiple choice and some essay and some performance test. And day two would be similar. There would be no day one, day two distinction, and you would only get one score, which would mean that it would be impossible for us to implement the idea that we had of giving people a choice. So therefore, we've recommended, the State Bar has, that New York adopt its own test. One of the things that we point out is it's going to take the NCBE 4 to 5 years to develop a new test. if New York does nothing, then we're going to be stuck with whatever the NCBE comes up with. For better or for worse, we knew what the UBE was when New York signed on to it. By doing nothing, we would be signing on to whatever the NCBE comes up with, even though the needs of New York may be quite different from the needs of other states. You know, as I said before, New York has about 15,000 test takers. I think Massachusetts has about 400. New York has a quite complex civil procedure code. New York does not have, New York's code of evidence is largely unwritten. It's largely case law, although there are some statutes. We think that we are not serving the public when we're producing lawyers who don't know what court to go to, or how to write a will, or what the requirements are for basic, simple matters. So we are recommending that New York have its own test and that we take the 4 or 5 years to develop it. When the UBE came in, it caught the law schools in New York quite by surprise, because they were training their students to take a test, and all of a sudden the rules of the game changed in the middle of the game. We don't want that to happen again. So the idea behind the 4 to 5 years is we develop a test. We've advocated that there should be a working group that includes representatives of academia. I apologize. And so that way, as the test gets formulated, the law schools are aware of what the new test is going to look like, and can start adjusting their curricula and their faculty decisions. You know, one of the things that's happened is there's been a significant drop off in students who take New York Civil Procedure. So as professors who teach New York Civil Procedure retire, law schools may not be hiring people who have that as their specialty. They may not be hiring people who have New York family law or New York trusts and estates as their backgrounds, because they're not teaching it anymore. So if you're going to teach it, you have to make sure that the law schools know that it's going to be taught, it's going to be tested, and that they're prepared to have the faculty in hand. And the other thing that we think is useful, when I went to law school, now I went to St. John's, our exams in a law school were very similar to the bar exam questions. So when you got to writing essay questions, we'd been already doing that for 3 years. We would like to have law schools have that ability to formulate their tests in line with what the bar exam looks like, so that their students are prepared to take it, and it's not a strange thing coming at them at the last minute.
Yeah, I recall from that time, I know that she's now the provost at Toro, Patty Salkin was then the dean. And I believe that there was sort of a transitional period in the adoption or implementation. That is, there was a real recognition of the need to switch in the middle of the stream and to begin to plan for that. I'm proud to say that we still offer New York practice as a course for students, but I wouldn't deny it's not a required course, and the enrollment is not what it was when it was a required course.
Because students aren't stupid. They want to take what they think they need to take in order to pass the bar.
Yeah, no, I think much of what we're talking about, everyone's being a rational actor, essentially. But this is you know, the incentives or the process has created this system. One last question that you touched upon, I think, in the Bloomberg piece, and I don't think we've discussed it yet, the idea of apprenticeship, is that something that the task force has thought about? Is that something that could realistically be implemented?
We have actually, Professor Kaufman is a big advocate of these alternative pathways. And the task force has made some nods in that direction. You know, a test can't capture everything that a lawyer does. So for example, one of the things that lawyers have to be able to do is negotiate, right? Whether you're a prosecutor, whether you're a civil lawyer, lawyers spend a lot of their time negotiating. How does a bar exam test your negotiation skills? Lawyers need to communicate. You have to be able to sit down and rationally explain things to a client. You know, you may be taught how to advocate, but where's the piece that says to the client, well, listen, maybe I can make these arguments for you, but maybe these aren't going to win, and maybe we got to think about another strategy here. Where's that piece? So we've thought about a pathway to practice that would include, while you're in law school, a supervised practice with either a civil firm, a criminal agency, nonprofit. We would not have you just do the practice without it being part of a graded discipline law school class. It wouldn't have to be through a law school clinic, but that would certainly qualify. The idea being that it's part of the academic experience, and it's also a way of making sure that the supervision and the work is meaningful. You know, we created a temporary student practice program for those who couldn't take the bar during the pandemic. And we found that we had people who were being supervised by their parents or siblings. We don't really know, for example, if you're working for a lawyer, if you're working on a brief, a contract, or you're just running the Xerox machine, or serving papers. How do we make sure that the supervised practice experience is meaningful? Even if a law student submits a brief, how do we know how close that is to what the law student submitted to the lawyer in the first place? So we think that for it to be meaningful, there should be a component that is controlled or supervised by the law schools, as well as by the people who you're practicing with. And frankly, while we've suggested this as an alternative, meaning that if you do this and you do this successfully, you could avoid taking the bar exam, at least in New York. If you practice in New York, how better can you learn New York law than to practice it, right? We could see this as a future companion to the bar exam, meaning that in order to gain admission, you must pass the bar and have some practicum. We've also proposed the potential for a form of diploma privilege through concentrated study of New York law. Meaning, if you want to show us that you know New York law, maybe the way to do it is by taking a sufficient number of credits in New York law and getting a sufficient, grade point average in those credits. So in essence, a major. And New Hampshire and I think Wisconsin have programs that are similar to this. So we think that that's a potential pathway as well.
Right. Well, we've discussed many things. I want to thank you very much for your time. And is there, I guess this is, kind of like a question and oral argument. Is there anything that you would add to our discussion that we haven't touched on?
No, the only thing that I would say is that the Court of Appeals is considering our recommendations. It has formed a group of judges and former judges and lawyers chaired by the Honorable Howard Levine, who was a retired judge of the Court of Appeals. And when he was on the Court of Appeals, he was the judge whose portfolio included looking at the bar exam, is currently studying these issues. And I am optimistic that the court will decide to do something by the end of the year. And by something, I mean make a conscious choice between staying with the NCBE or developing some alternative. Because I think the Court of Appeals realizes that it should not just make a decision by indirection and just sit back and do nothing. That if it decides that it wants to trust the UBE, trust the NCBE, then it should make that decision volitionally. And if it wants to do something different, to decide what that should be, and to get that process started.
Yes. So, and certainly for those of us who teach, for those of us still practicing, And certainly for those of us who are law students who may be listening to this, uh, we wait with bated breath to see what the next steps will be or what the next action will be. Again, I want to thank you so much for taking the time to talk with me. And I think that's the end. Thank you.
Thank you very much. It's been fun.